Few legal grounds carry as much emotional weight and human tragedy as psychological incapacity. Each case under Article 36 of the Family Code is a story of two people once bound by love, now separated, not by betrayal or choice, but by the quiet erosion of what makes a marriage human: understanding, empathy, and commitment. Behind the pleadings are lives that have unraveled, children left to wander, and spouses burdened by the question of whether love can survive when the mind cannot sustain it. Psychological incapacity remains one of the most litigated and misunderstood grounds for the declaration of nullity of marriage. It sits at the intersection of juridical reasoning and clinical diagnosis, requiring lawyers and mental health professionals to work in tandem. For us practitioners, the success or failure of such petitions rests on our ability to translate psychiatric classifications under the DSM-5, TR, and ICD-11 into legally cognizable proof of incapacity. The law demands not proof of madness, but of a psychological cause so grave, enduring, and antecedent that it renders a person truly incapable of fulfilling the essential marital obligations of love, fidelity, respect, and shared life. In every petition, the task is both legal and deeply human: to seek justice amid the ruins of what once a promise of forever. At the heart of Article 36 is not the breakdown of marriage, but the incapacity to live it out. The provision is not a tool for divorce. It is a remedy for marriages void from the beginning. The incapacity must exist at the time of celebration. It must be so deep-seated that even love, effort, or counseling cannot cure it. This is where law meets psychology. To prove incapacity, we must show not just failed conduct, but an inner inability to fulfill what the law defines as essential marital duties. Jurisprudence evolved as far as Article 36 on psychological incapacity is concerned. Starting in Santos versus Court of Appeals, the key holding being it is defined as a mental, not physical, and must exist at the time of marriage. The litigation value is it introduced juridical antecedents. In Republic versus Molina, the key holding imposed strict standards, antecedents, gravity, incurability, and expert proof. Framework for early petitions. In Marcos versus Marcos, it relaxed the Molina doctrine. Expert testimony is not indispensable, and this allowed lay corroboration. In Tan Andal versus Andal, it recast psychological incapacity as a legal concept, not a mental or medical disease, recognized it as a deeply rooted personality structure causing inability to perform essential obligations. This is a landmark calibration, liberal evidentiary rule. In Yokogawa Tan versus Tan, the key holding here is it clarified that incapacity may be proven through behavioral manifestations even without a formal diagnosis, provided totality of evidence meets the Tan Andal standard. Now, this strengthened behavioral proof approach. In Buwado versus Galvez-Buwado, it affirmed that psychological incapacity can be inferred from patterns of conduct consistent with the DSM-ICD personality pathology. It reiterated that courts determine legal incapacity, not psychiatrists. Thus, it reaffirmed collaborative medico-legal roles. And in the latest case of Green versus Green, the holding here emphasized due process and evidentiary balance. Psychological incapacity must not be presumed from marital failure alone. Both expert and lay testimony must be evaluated in context. Thus, it cautioned against pathologizing marital discord. Defining psychological incapacity after Tan Andal case. In Tan Andal versus Andal, the Supreme Court transformed how we understand psychological incapacity. It's no longer about diagnosing a mental illness. It's about identifying a legal incapacity that prevents a person from living out the essence of marriage. This incapacity is not a matter of will, but of capacity, a deep-seated inability arising from enduring personality traits. The law now focuses on whether a spouse can truly fulfill the core marital obligations of love, fidelity, respect, cohabitation, and support. It's not about fault or unwillingness, but about an inherent incapacity to give what marriage requires. In short, Tan Andal shifted the conversation from pathology to personhood, from medical diagnosis to human limitation. When proving psychological incapacity under Article 36 of the Civil Code, the three legal requisites are necessary: juridical antecedents, gravity, and incurability. This must be established not by theory but by concrete evidence that paints a full psychological and behavioral portrait of the person. Personality disorders, as defined in both the DSM-5-TR and ICD-11, describe enduring patterns of behavior and inner experience that are rigid, pervasive, and deeply rooted in one's personality structure. These patterns usually form in adolescence or early adulthood, long before marriage, which makes them highly relevant to Article 36 cases. From a medico-legal perspective, this clinical permanence directly mirrors the three legal requisites of psychological incapacity. As I have said, juridical antecedents because the traits pre-exist the marriage. Gravity because they distort one's capacity to love, commit, and live responsibly as spouse. And lastly, endurance or incurability because such trait persists despite effort, counseling, or time. When the law speaks of incapacity that is grave, antecedent, and enduring, it often reflects the same reality that psychiatry observes, that some people are not simply unwilling, but truly unable to sustain the emotional and moral dimensions of married life. In the courtroom, we often hear of psychological incapacity in abstract terms, but here, the personality disorders recognized in the DSM-5 TR and ICD-11 give it substance. These disorders help us understand how certain enduring traits make a person truly incapable of fulfilling the obligations of marriage. Let's begin with narcissistic personality disorder. Individuals with narcissistic traits are driven by grandiosity and entitlement. They lack empathy and see relationships as extensions of themselves. From a legal standpoint, this disorder satisfies juridical antecedents because these traits form early in life. It is grave, as the person's self-absorption destroys reciprocity, the capacity to love selflessly. And it is enduring. Since narcissism is notoriously resistant to therapy or change, such a spouse cannot sustain mutual respect, intimacy, or genuine partnership. Next is the antisocial personality disorder. Presents perhaps the starkest incapacity. Here we see deceit, irresponsibility, and disregard for moral and social rules. Legally, this behavior shows antecedents because it is lifelong, typically beginning in adolescence. It is grave because it obliterates fidelity and trust, essential pillars of marital life. And it is enduring, as antisocial behavior persists even after repeated consequences. The law recognizes that a person incapable of moral responsibility cannot truly bind themselves to the covenant of marriage. And when it comes to borderline personality disorder, it reflects profound emotional instability, impulsivity, fear of abandonment, and intense shifting relationships. These traits often surfaced early, fulfilling the requirement of juridical antecedents. They are grave as the resulting instability and volatility make marital life chaotic and destructive. They are enduring too because these patterns recur despite counseling or separation. In sum, these clinical portraits reveal that psychological incapacity is not about refusing to love. It is about structurally unable to sustain love, commitment, and trust. The DSM and ICD simply give language to what the law already contemplates: a permanent incapacity existing before the marriage, grave in its effects, and enduring in its nature. When we move into these next three personality patterns, the obsessive compulsive, dependent, and avoidant personality disorders, we begin to see how psychological incapacity can manifest not through aggression or deceit, but through rigidity, fear, and withdrawal. These are the quiet incapacities, often less visible but equally destructive to marital life. Let's start with obsessive compulsive personality disorder. This is not the same as the clinical OCD of repetitive behaviors, but a personality style marked by rigidity, perfectionism, and control. Such individuals are often driven by rules and order, leaving little room for warmth or emotional connection. From a legal standpoint, these traits are antecedent because they are part of one's enduring character long before marriage. They are grave since this inflexibility prevents emotional intimacy and mutual adaptation. And they are enduring because this is not a temporary attitude but a lifelong personality structure, unyielding even with counseling. In marriage, this translates into dominance, coldness, and the inability to share vulnerability. Now consider dependent personality disorder. These individuals live with a deep fear of being alone. They cling to others for reassurance, often surrendering autonomy and judgment. Such dependence is antecedent, often learned from early family dynamics or overprotective environments. It is grave because it makes equality in marriage impossible. The relationship becomes one sided, parent to child instead of spouse to spouse. It is enduring too, as dependency rarely changes without long term therapy. The result is a partner incapable of true partnership, someone who cannot stand alone and thus cannot truly stand with another. And finally, avoidant personality disorder reveals incapacity through isolation. These individuals fear criticism and rejection so deeply that they withdraw from intimacy altogether. The disorder is antecedent, typically rooted in childhood rejection or humiliation. It is grave because avoidance prevents communication and shared life, the very essence of marital union, and it is enduring, persisting as a lifelong pattern of self protection. In all three, the incapacity lies not in choice but in structure, an enduring inability to sustain the openness, trust, and flexibility that marriage requires. These patterns demonstrate that psychological incapacity under Article 36 is not confined to overt pathology. It may quietly erode a marriage through emotional distance, dependence, or detachment that has existed long before the vows were ever spoken. These final three personality disorders, the paranoid, histrionic, and schizotypal, reveal the more subtle but deeply rooted psychological structures that can render a person incapable of living out the essential obligations of marriage. Each of these patterns distorts intimacy and trust, striking at the very foundation of a marital relationship. Let's begin with paranoid personality disorder. This disorder is characterized by chronic distrust, suspicion, and hostility. Individuals with this pattern constantly question motives, interpret affection as manipulation, and project their own fears onto their partners. In law, these traits satisfy juridical antecedents because they stem from long standing cognitive distortions that begin early in adulthood. They are grave, as this deep mistrust destroys the mutual confidence and fidelity required in marriage. And they are enduring because such suspicion is resistant to therapy and tends to persist across one's lifetime. A paranoid spouse lives in constant emotional combat, making peace, security, and love almost impossible. Turning to histrionic personality disorder, this pattern is marked by exaggerated emotions, attention seeking, and superficial relationships. Such individuals crave admiration, dramatize affection, and struggle to sustain authentic emotional bonds. Legally, this condition is antecedent, as it reflects a long term personality style rather than a situational phase. It is grave because the person's need for validation prevents genuine commitment and emotional stability within marriage, and it is enduring, being a fixed relational pattern throughout adulthood. In the courtroom, this may manifest as a spouse who thrives on constant affirmation but cannot provide the emotional consistency marriage requires. Finally, the schizotypal personality disorder involves odd beliefs, eccentric behavior, and significant social anxiety. Traits that isolate the individual even within intimate relationships. These characteristics are antecedent, often emerging in adolescence and persisting through life. They are grave because they make sustained intimacy and shared reality impossible. And they are enduring, belonging to the schizophrenia spectrum, chronic and only minimally responsive to treatment. A schizotypal partner may appear distant, detached, or lost in a private world, unable to meet the emotional and practical demands of marriage. Together, these disorders highlight how psychological incapacity under Article 36 is not about momentary conflict or weakness, but about enduring distortions of personality that predate the marriage, render a person incapable of its obligations, and persist despite time or intervention. The law recognizes that some relationships fail, not because of malice or neglect, but because one party simply lacks the stable psychological foundation to fulfill the covenant of marital partnership. Strategy for the complainant. The goal in prosecuting a case under Article 36 is to translate the language of psychiatry into the language of law. Courts do not decide on the basis of a diagnosis. They decide on evidence that shows incapacity. That means we must move from the abstract to the concrete, from medical terms to observable behaviors that prove juridical incapacity. The first step is crafting specific pleadings. Avoid vague claims like the respondent was emotionally immature. Instead, describe concrete actions: abandonment, deceit, manipulation, or emotional coldness that reflect an inability to sustain marital duties. The petition must tell a story, not just a quote from a textbook. Second, obtain an expert report that connects those behaviors to psychological incapacity. The psychiatrist or psychologist should explain how the DSM or ICD findings reveal a personality structure that makes the spouse truly incapable, not merely unwilling, to love, commit, and remain faithful. The report should be interpretive, not diagnostic, aligning with Tan Andal's teaching that psychological incapacity is a legal, not clinical concept. Third, corroborate with lay testimony. Family members, friends, and colleagues can confirm that the behavior exists long before marriage, establishing juridical antecedents. Their stories give life to the diagnosis, showing the pattern and its persistence. Fourth, demonstrate endurance despite therapy or separation. The incapacity must shown to persist even after counseling or time apart, proving it is characterological, not circumstantial. Finally, ensure consistency with Tanandal and Buwado cases. Incapacity must be rooted, grave, and enduring, but need not be medically incurable. Use behavioral evidence over diagnostic labels because what convinces the court is not the name of the disorder but the lived behavior that makes marriage humanly impossible. In short, our role is to bridge the disciplines, to let psychiatric insights serve the law's pursuit of truth. The best petitions are not medical dissertations, but human narratives of incapacity grounded in credible evidence and clear legal reasoning. The selected text outlines different types of evidence that can be presented in cases of psychological incapacity under Article 36 of the Philippine Family Code. Each type of evidence serves a specific role in the legal process, helping establish claims related to the psychological condition of a spouse during a marriage. Let's break down each component. Expert testimony. Its role. Expert testimony refers to the statements made by a qualified professional, such as psychologist or psychiatrist, who can assess and explain an individual's personality pathology. Essentially, their mental health issues or disorders that may influence their behavior in a marital context. The legal value of this is that the expert's testimony is described as persuasive, not conclusive. This means that while experts can provide insights and opinions that may significantly influence the court's understanding of a case, their testimony alone does not definitively prove or disprove psychological incapacity. Instead, it is one component of a larger body of evidence. As for the lay testimony, this involves statements from non-experts such as friends, family members, or acquaintances who can observe and describe the behavioral patterns of the spouse in question. These observations can confirm how the spouse has acted over time. Lay testimony serves to support antecedents and endurance, which suggests it can help establish history of behavior, which is antecedents, and show that these behaviors have persisted over time, which is endurance. This kind of evidence can be crucial in demonstrating that the psychological issues are not just situational or temporary, but have been a long-standing problem affecting the marriage. For the medical records, this referred to documented evidence of a person's mental health, history, diagnosis, treatments, and other relevant medical information. Such records are described as corroborative proof and provide objective evidence of persistence. They can substantiate claims of psychological incapacity by offering clear, documented history and evidence that mental health issues are ongoing, thereby supporting the arguments presented in court. In summary, the selected text categorizes evidence related to psychological incapacity into three types: the expert testimony, lay testimony, and medical records. So each type has a defined role and varying degrees of legal power, emphasizing the multifaceted nature of proving psychological incapacity in annulment cases. This structure approach underscores the complexity of assessing psychological conditions in a legal framework, reflecting the emotional and human elements at play in such cases. When defending against a petition under Article 36, the strategy centers on dismantling the alleged psychiatric nexus between the supposed disorder and the incapacity to perform marital obligations. The objective is not to deny difficulty in the marriage, but to demonstrate that what is being portrayed as incapacity is in truth normal human imperfection. First, challenge the psychiatric nexus itself. Question whether the DSM or ICD criteria were properly met, or if the expert merely offered a general impression without a rigorous clinical basis. Under Rule 130, Section 49, opinion testimony must be based on personal knowledge and sufficient examination. If no direct evaluation was conducted, emphasize that the opinion lacks the probative foundation required by the rules of evidence. Courts in Buwado and Green have consistently held that while expert opinion is persuasive, it is never conclusive. Next, argue post-marital or situational origin. Many behavioral changes occur due to stress, substance abuse, or relational conflict. These do not meet the requirement of juridical antecedents. Citing Green versus Green, remind the court that incapacity must predate the marriage and be inherent in the person, not a reaction to the marriage itself. If the supposed symptoms appeared only after years of cohabitation, the incapacity is not antecedent but circumstantial. Then, contest the gravity or endurance. Show that the respondent functions effectively in work, family, or social relationships. Evidence that contradicts the claim of grave and enduring incapacity. Present proof of counseling, behavioral improvement, or successful adaptation. This show that the condition is curable or manageable, and therefore not the kind of enduring incapacity contemplated by law. Finally, invoke the presumption of validity of marriage. As the Supreme Court held in Santos versus Court of Appeals and reiterated in Green versus Green, marriage enjoys the presumption of regularity and permanence. Doubts must always be resolved in favor of validity, not nullity. In short, the defense must remind the court that imperfection is not incapacity, conflict is not dysfunction, and change is not impossibility. The law protects marriage as a social institution, and unless incapacity is clearly antecedent, grave, and enduring, the presumption of validity must prevail. In presenting or defending a case under Article 36, every litigation stage demands strategic precision. Both petitioner and respondent must understand where the burden lies and how the evidence should be crafted or countered. During petition drafting, the petitioner's success begins with specificity. The pleadings must detail concrete, observable behaviors linked to psychological incapacity, not vague claims of incompatibility or emotional immaturity. This description should connect with DSM or ICD findings that explain why the spouse is incapable, not merely unwilling, to fulfill marital obligations. On the other hand, the respondent should attack the petition's vagueness. If antecedents is not clearly shown, if the traits appeared only after the marriage, the petition already falters. The absence of premarital behavioral evidence undermines the legal requirement of juridical antecedents. In the stage of expert testimony, the petitioner's goal is to demonstrate enduring incapacity, a personality-based inability that persists despite time or counseling. The expert must articulate this as a lifelong psychological structure, not a situational episode. For the defense, this is the opportunity to question the methodology, bias, or clinical sufficiency of the evaluation. Was there a direct examination? Were DSM or ICD criteria rigorously applied? Did the expert rely on hearsay from only one party? Weaknesses in method can erode credibility and probative weight. When lay witnesses take the stand, the petitioner must use them to confirm long-standing maladaptive behavior, evidence that incapacity was evident even before the marriage. These witnesses humanize the clinical findings. Conversely, the respondent should present contrary testimony from family, friends, or colleagues showing that the spouse functioned normally in other areas of life, as a parent, employee, or friend, thereby challenging gravity and endurance. Finally, in memoranda, the petitioner must tie all the evidence back to the essential marital duties enumerated in Articles 6871 of the Family Code. Love, fidelity, mutual support, and shared life. Each piece of evidence should show how incapacity prevented those obligations from being fulfilled. For the defense, this is where Tan Andal and Green become vital tools. Both reminds us that not all marital failures amount to incapacity, and that the burden of proof lies on the petitioner to establish incapacity as grave, antecedent, and enduring. Ultimately, this stage-by-stage approach reflects how psychological incapacity cases hinge not on drama or sympathy, but on evidence that satisfies legal precision and clinical realism, where every fact, every witness, and every word in the pleading must converge to meet or defeat the strict standards set by jurisprudence. In conclusion, Tan Andal versus Andal, reshaped our understanding of psychological incapacity, reminding us that it is ultimately a legal concept, not a medical diagnosis. The DSM and ICD remain helpful tools, but they do not decide cases. The courts do. What must be proven is incapacity that is antecedent, grave, and enduring. One that existed before the marriage, deeply impairs the ability to live it, and persist despite time or intervention. At its heart, Article 36 is not about assigning blame, but about discerning the truth. As lawyers, doctors, and officers of justice, they are tasked to let law and medicine meet with compassion, to ensure that the pursuit of justice brings healing, not harm, to those whose lives and marriages have already broken under the weight of incapacity. And in closing, justice must be compassionate enough to see incapacity where others see fault, and discerning enough to see truth where others see weakness.